Welcome to the Domain Name Law Show. This is episode number 215. Thanks for joining us. We are streaming also on YouTube, if it works this week. My name is Todd Ryan. I'm one of your hosts. There's three of us here every week, Tuesday at noon Pacific, 3 p.m. Eastern. My other two co-hosts are Jeffrey Newman and David Michaels. Hi, Jeff. How are you today?
I am doing great. Yeah, it's mid-April. Um, it's spring break for my youngest daughter, so trying to enjoy some time with her. And weather's nice. It's a little rainy, but all good.
Fantastic. So I'm West Coast, Jeff is East Coast, and David is Northeast Coast. Anyway, north, he's not even on the coast, but anyway, up near Toronto in the area. Hey, David, how's everything going where you're at?
It's all right. We still have another blast of winter. It doesn't want to go away. No snow yet, but it's in the forecast.
Well, I appreciate everybody joining us. Like I said, we're here every Tuesday, noon Pacific, it's U.S. time, of course, 3 p.m. Eastern. So what we always do is we cover a few domain name legal cases if I can find them. Sometimes I'll add in domain industry news to our outline. And then we review a few UDRP cases. Those are domain disputes. So we review a few domain disputes. And then now at the when we finish the domain disputes, if you have any legal questions for Jeff or for David, and of course, I try to add my 2 cents for what it's worth, raise your hand and we'll bring you up once we're done reviewing our UDRP disputes. And then we'll let you ask the lawyer some questions. But people have a lot of legal issues or questions sometimes when it comes to domain names. Am I allowed to register this? Hey, I got this cease and desist. What should I do? We don't give These lawyers don't give specific legal advice, but some general advice and some good general advice too. If you want to follow along to what we're going to cover today, you certainly can go to dnlshow.com/outline and you'll see what we're going to cover today. I just added a link. I got to say, you just got to check out dnw.com. That's Domain Name Wire, because Andrew Alleman is constantly adding some great content there that's legal related. And for example, too, there's a few articles in there, but one, I get it directly from escrow.com, their report for Q1. But since Andrew made me aware of it before I even knew it was out, give him credit and would like for you to check out his website. Of course, it's the least I can do, attribute some of the articles to him, especially that's where I initially find them. But there was a case that I just added that Andrew made me aware of yesterday, the Alo Yoga case. We covered ALO.com. It was a domain dispute that the respondent won. So he got to keep his name, ALO.com, which makes sense. If you just look at it from a high level, geez, there's a three-letter, can be used for different things. Why would it, unless there was specific targeting, which there wasn't in this case. But anyway, this company, Alo Yoga, that lost the domain dispute, actually took them to court and won in a cyber squatting lawsuit. So they have the name now. And, we're maybe touch on it, although the guys, my co-hosts, probably haven't had a chance to read it yet. But anyway, okay, so if you're looking at the outline at dnlshow.com/outline, you'll see the first piece of legal news I was going to touch on, or industry news really. This was escrow.com reported that there was a jump in domain sales in Q1. So in first quarter of 2025, there was $107 million. That's US dollars, because they're in Australia and they have all their numbers in Australian dollars. Anyway, it was 107 million US dollars in domain sales. That was the highest quarter since the first quarter of 2023, which I guess was their highest ever. But this was up 20% over 2024. It's a good indicator. Not many names or sales are processed, transacted through escrow.com. I mean, I've only had one or two in the last year. I wish I had more, because usually they're bigger sales. But David, you're with me. We're domain investors. times are slow in the domain investing, Um, so what does this number mean to you? Okay, so other people are having sales. It still keeps you positive, even if it's not directly affecting you or me. What do you say?
I think the people who are selling names right now are selling them in certain markets that are still booming, like crypto. Crypto is going through a boom right now still, like abtc.com. And um, I've seen a whole bunch of smaller sales. I'm trying to figure out how would anybody think about registering these domain names? And it turns out they relate to some new cryptocurrency platform or whatever coin. So yeah, the regular traditional domain name business is in a slump right now. Businesses are feeling the recession, and they're uncertain as to the future. They're not investing.
Yeah.
Big problem.
On this Friday, I'm doing a room with Josh Reason about domain investing. I bring it up because on this show, we're talking about domain name law, and we're going to get into some legal issues with domain names, and then we're going to review UDRP cases. And then if you have questions, like I said, you can raise your hand and ask the lawyers questions, whatever, if they're domain name legal related. On Friday, that's this Friday, today's the 15th, that would make that the 18th, at 11 a.m. PSD, 2 p.m. EST. You can see it on my timeline. So Josh and I are going to be talking about exactly what David just brought up. Trends. Sometimes you can purchase names, you can register names, hand register names or find them on the aftermarket at low price because it's a new trend and you might have to hold that name for years until that trend turns into, gets more entrenched in, say, business, and then domain names may be valuable. So what David was bringing up about, BTC, yeah, when we first started domaining, no one was worried about registering BTC names in the end of the 90s, the early 2000s. Of course, the last decade, BTC has been popular. And then as crypto becomes more popular, there's all sorts of trends around that, from DeFi to, stable coins. So, trends can make you, recognizing solid trends in the domain investing space can make you some money. Something else I was going to mention about the Josh and I show. Anyway, it's a place where we can talk about specifically domain investing. And okay, so that's Friday. But I wanted to get to, on our outline, there were some legal stories that are Mike Mann sold iPhoneonly.com over this past week for $2,200. And people were asking, geez, it's pretty interesting. I thought iPhone was a trademark. How can you, is it okay to register trademarks and then selling them? Now, that was probably one of the lowest sales I've seen Mike post, $2,200. But I wanted to ask, first, David, I know you commented on this, so first I'll ask you and then go to Jeff. What trademark concerns are there with domains like this?
Well, first of all, iPhone now is famous, so registering that today would be a problem. But back in the day, that was a generic term for internet phones. So that's the problem. Like, you don't know, and we're going to talk about some cases today that seem generic, but are being used in a way that seems to infringe some trademarks. Whether or not they're valid is another question. But trademarks are an issue, so always check for trademarks. Even like with this ALO case, all the guy had was probably random PPC ads that he didn't control, and somehow yoga ads showed up there. I noticed in the complaint that they didn't mention the UDRP decision, so that's interesting.
I look forward to talking about that. Jeff, about iPhone only, and David makes a good point. Back in the day, we put I in front of all sorts of domains. So if you had iPhone, iComputer, iStock, anything. So that is a good point that David brought up. Now, of course, it's become famous. So when what rights does the person, say the person purchasing it for $2,200, it's not Apple, what rights do they have now, acquiring a name like iPhone only? How can they use it legally?
I mean, there's plenty of ways it can use it legally, right? I mean, we've discussed a number of UDRP cases. There's, fair use of it. So if they are have it as a site that's describing the benefits of the iPhone, or um, criticizing it, right, in some sort of non-commercial way, then that's one way you can use it. The other types of cases we've seen are cases of suppliers or repair people um, that work exclusively on iPhones, or that use it in accordance with some of the Oki data cases that we've talked about, where a reseller, whether authorized or not, or a repair person, whether authorized or not, may still have the right to use that trademark in a domain name, provided that all the things we talked about, there's a disclaimer, or there's a way that it makes it clear to the user that this is not Apple. If they really use that site to only talk about iPhone and Apple, presumably, as opposed to including Android stuff on there as well. So there are a number of ways that they could use it legitimately. Um, I would never recommend including a famous mark in your domain, but there are ways it can be used, and they'll just need to be careful.
Thanks, Jeff. And that's important to know. I mean, with a name like iPhone only, that really lends itself to the fair use, meaning, all right, if you really are doing that as a reseller, offering iPhones only, and you're saying what mark, I mean, what product you're selling only, and then you have some disclaimers like Jeff mentioned on your site to say we're not related to Apple, but we do have fair rights. This is if you're having a commercial site, you really need to be careful. Jeff mentioned if you're just talking about news on the iPhone and iPhone only experiences and so on, then you have a little more leeway when it's non-commercial, at least in the courts. But okay, so this person purchased it, and for 2200, they need to be careful how they use it and what type of ads may be placed on there, if there's any PPC ads, because then of course Apple could file a UDRP, say, hey, they acquired it much after our mark has been famous. Everybody knows iPhone now, and if they're definitely if they contact Apple and say, hey, do you want this? I have this name. Then it could be, I mean, Apple could claim targeting and probably be successful. But interesting. I'm glad that. So Mike unloaded it. Seemed like Mike knew that, you have iPhone only. He only asked 2,200. He probably wanted to get that off of his balance sheet or off of his domain marketplace. All right. Once again, if you want to follow along, you can check out our outline at dnlshow.com/outline. The next thing I had up was, okay, we'll just breeze over this, but a California law firm filed suit to take down an imposter site. And I thought it was interesting. So it was a lawsuit. They probably could have tried to take it down in other ways, I would think. Maybe they tried. I didn't look. I mean, the lawsuit didn't mention it. But basically, this was a law firm that said, hey, there was an imposter site that had our whole law firm up there, our logo, our contacts, all the same lawyers' names and everything from our website. They just had a different phone number going to Ghana or somewhere. I don't know where it was going. And it seemed like a pretty easy case, for the courts to take down. But I don't think it seemed like they could have tried another way to take it down. But maybe there was overseas hosting. We're having problems. Did either of you guys look at this link? Sorry to make you spend time on really an unimportant case, but any comments?
Yeah, I mean, I took a look. Let me just going back to my notes here. This is so a couple funny, maybe not so funny things, but this law firm that filed this suit, right? Um, it made a mistake in its filing, because I looked at the Pacer history, and it didn't sign the complaint. And if you look at that link, you'll see that the complaint is unsigned. And so the court essentially dismissed it, and said, look, you don't meet the rules of a complaint, so you got to file an amended complaint. And they did. So, but you would think that a law firm that files a case would know something as basic as signing the complaint. I thought that was kind of funny. Um, the and the other thing is, for some reason, and I don't know why, they didn't ask for a temporary restraining order. Um, I guess maybe I'm not sure. Well, you would think, yes, you would think you'd ask if someone's using it fraudulently. You would think that they would have asked for an ex parte temporary restraining order to lock the name down and to um, maybe even shut it off while this case is pending. If it really was being used in a scam. And so to me, that was left me kind of puzzled. Like, why would they not file for an injunction? So, David, I don't know. Do you have any thoughts?
Yeah, that's for sure. I'm just looking at their website, ggtriallaw.com. So they practice in the intellectual property area. They do high stakes litigation, and they made a bunch of mistakes. Why not just start off with the DMCA and do the lockdown? And why did they file the in rem action in Arizona as opposed to Virginia? Um, how did they get service? Because Arizona requires service.
Well, they serve name cheap, right?
That's not the same thing.
Well, no, but all you have to do in an in-ram action is serve um, the property itself, right? Because it's in rem and the property's located
Right.
in Arizona. Now, presumably, they're going to have to try to also send notice to the party in Ghana just to try, right? Because they didn't even like make a showing that they couldn't. They just kind of alleged it since they're in Ghana, they can't get jurisdiction. But yeah, it was very odd to me that a trial firm. I mean, look at it's funny if you go to the lawsuit, look at the PDF, it's not signed, and so it was kicked out as it should have been. Um, but yeah, I have this on my uh, Pacer watch list to see if there's any updates.
This is an important case leading into our next story about the Allo case. So I want people to know in this particular case, I added it. Now I say I added it for this reason, but it is an important reason. This law firm, first, like David mentioned, could have probably filed a DMCA takedown and said, "Hey, they're using our copyrighted materials," and maybe they tried. Let's assume they tried, and they tried to contact a host that was overseas somewhere because this domain owner's in Ghana, and say the host doesn't acknowledge these U.S. laws or a DMCA takedown, saying, "Hey, please take down this website." So the law firm in this case, just like the yoga company in the next case, filed an in rem action. So I want to ask you, David and Jeff, please explain this. And first, what is an in rem action, and when are you allowed to file an in rem action?
Well, in rem is against a thing. So it's either against your property, like land, or your domain name, or your car, or anything like that. That's what in rem is. It's against a thing, not a person.
Right.
Now,
So, oh, go ahead.
go ahead. Well, you
I
can
was just
continue.
going to say, there's when you file in rem, you have to show the court that you can't get jurisdiction, or likely can't get jurisdiction over um, the owner of the domain, the property, and that's why you're bringing it in rem. Also, in rem is limited to just the domain name, the transfer of the domain name itself. You can't include things like damages, um, or any kind of monetary relief. It strictly is only about the domain name. So, which is, if that's what you're seeking, transfer the domain name. That's fine, and that's what most people that file in rem actions are seeking. Um, if you want damages or anything like that, you can't use in rem.
Fantastic. I mean, the reason I wanted to bring that up is because, right, when can you do it? When you can show that you cannot serve or you cannot have a mutual jurisdiction with this particular owner of this, whether it's a domain name or whether it's land, like Jeff said. So, getting to this next case, last year we reviewed this UDRP decision for the domain name ALO.com. This yoga company, I think it was yoga clothing, named Alo Yoga, filed this UDRP. They lost the UDRP. The domain owner got to keep the name. Well, this Alo company, the yoga company, has these attorneys at Wiley Rhine. It's wiley.law. I bring it up because what really frustrates me and pisses me off when, I know, lawyers get hired, but they decide whether or not they want to take a case, especially like this. And they wanted to take the case. They filed this in rem action against the domain name. So, David, I know you looked at this a little, and then Jeff, you can comment. So why was this one filed in rem? I mean, they just could not. I thought we had some information on the domain owner and where they're at through the UDRP. And tell us about this case. Why was it successful? Why did this company, win this case? I mean, so far, and get the domain transferred to them. Was it, merely because of the PPC links? Tell us a little bit.
I haven't read the whole thing yet, but from what I can gather, it looks like they did not disclose that there were 2 prior UDRP decisions that denied transfer. I think the domain was registered at GoDaddy, if I remember correctly. So I guess they wanted to, instead of appealing the UDRP decision, they wanted to wait a year and then file in rem in Virginia, where they could get around that mutual jurisdiction part of their original complaint. And that, I think, is a problem. So I think they need to be a little bit more candid with the court. What do you think, Jeff?
Yeah, and I have not read the complaint. So I don't know what they did or did not put in the complaint. But, it's always one of the dangers if you don't respond. Well, they filed an in rem action. Yeah, it's something I really would like to kind of look at, because I don't know. I'm just trying to look. Yeah, we don't know what they disclosed. We don't know if the court had forced any kind of notice or tried. I'd have to look at the whole docket.
Yeah, Jeff, I want to look at this whole complaint myself. So this one I just added to our outline. We're going to keep it on for next week. The domain name is ALO.com, as I mentioned, so people can, come back next week. We're going to spend some time on this. And that is, it was a domain that the UDRP was filed against it. The respondent, the panel ruled the respondent gets to keep the domain name because the complainant didn't prove their case in successfully win all the points of the UDRP, but yet then they went ahead and filed this cyber squatting case, an ACPA case, and they have succeeded so far, and it doesn't appear that there's going to be an appeal. I mean, anyway, so next week we're going to talk about ALO.com, and today on the agenda we're going to speak about another acronym that, these companies come after these short domain names, and whether it's a word, say like YET.com, which I saw was on a Grit Brokerage's newsletter today. They send out a newsletter each week. A lot of great names on there. If you're not a member, if you don't get the Grit Brokerage newsletter, well, I'd recommend getting that. If you're a domain investor, there's always some single words on there that priced pretty nice. But anyway, I was saying about a domain like YET.com. Yeah, it's a word yet, but it is also an acronym. So when companies come after these 3-4 letter domain names, even 5 letter, like we're going to see in some cases today, it's frustrating when there's several uses for these short domain names, but yet someone thinks, no, we're claiming we have a trademark to it, and even if you're in outside of the category, we still have a lot of rights anyway. So we're going to go over ALO.com, the court case, next week. If you're looking at our outline, we're rolling right through it. Okay, so now we're down to tomorrow. Yeah, Jeff, are you going to be part of this call? It's an ICA expert call tomorrow on ICANN's proposed new domain name transfer policy. And every registrar has all these different policies for transferring domain names. So I think this is going to be a valuable call. That's tomorrow. And if you are interested in participating in it, go to our outline, dnlshow.com/outline, and you'll see B5 ICA expert call, and you can find the link there to go ahead and join and listen in. But Jeff, are you going to be part of that? David, what do you guys think?
I mean, I will listen to it after the fact. I have a conflict with that call, but I will definitely listen to it afterwards. Because for members,
Yeah.
at least, yeah, for members, that's another good reason to be a member, is that they send out the recordings if you can't make it.
Yeah, I'll definitely check it out.
Yeah. Anyway, so transfer policy is changing. A lot of us domain investors, we sell names. You buy a name and you wonder how long is it on lock, and different registrars have different policies. So check out that on the outline, and you can see how you can just listen into the call. It's tomorrow morning, 10 a.m. Pacific, I believe, and that's 1 p.m. Eastern. We're almost to our cases. If you have a question for the lawyers, raise your hand and I'm going to bring you up in about, I don't know, 20 minutes, because then we'll be done with our cases. It's me wishful thinking. Also, I wanted to mention, okay, if you're applying for a new GTLD, go to tldstrategies.com. That's a joint venture that Jeff and I put together with our companies. JJN Solutions is his consulting firm, and American Business Capital is my registered investment advisor. We joined together to offer some services, a lot of services, to individuals and entities basically applying for a new GTLD and ICANN's next round. And it's heating up, let's say, because the window's going to open for applications. Really looks like next May. I mean, things are on track. So it's time to really get your budget straight and start preparing for that process. So please check us out, or share with anyone you know who is interested in applying for a new GTLD and ICANN's next round. Visit tldstrategies.com. Thank you. And I'll get to our cases now. This first one, so I was on LinkedIn and I saw Doug Eisenberg posted something, and I know my attorney friends, they're all friends. Doug's a lawyer. Doug is I think he's a panelist too. I can't remember, but how do you know Doug, Jeff? Is he is a
Doug's been he's been a panelist, but he's also been pretty active in the into the Trademark Association community for a long time. And he's been, posts a lot of, he had a blog there for a long time. He's done these UDRP UDRP videos. So he's pretty well known in the community, in the trademark community.
Yeah, and I see his name all the time. I hear people talk about him. I've never met Doug, I don't think, in person, but everybody else knows him that's in the domain name legal space. Yeah, and you mentioned INTA. I know there's a big event coming up in San Diego in May, and that's really basically the, what's that stand for? International Trademark Association or something close.
Yep, you got it.
But anyway, basically a lot of the brand people. So, we talk about that. The domain lawyers, it's usually 20%. When I'm talking about a bunch of domain lawyers, it's usually 20% of them are pure, and I say pure domain name lawyers. Like, they've always represented domain name owners. They really come from sort of the domain industry, our perspective. A little like Jeff, that they've worked, many of them have worked, like Jeff and like our guest John Berryhill from before. They've worked for registries, they've worked for registrars, they've worked with domain companies, and they are businessmen, and they're, of course, attorneys and panelists, some like Jeff. Well, most of them, I say those are like come from the domain industry perspective. Most of the lawyers, even if they're now panelists or they do represent domain owners, most of them started out, they represent brands, and they always have they're biased towards brands. I mean, Jeff, when we speak to a lot of the lawyers on some of the calls, a lot of panelists, they're lawyers, and they just can't can't help but lean towards the brand. And what I mean by that is, soon as a brand, files a complaint to UDRP, it's like, they automatically, I think, a lot of panelists and a lot of the brand lawyers specifically, of course, they're like, well, the brand, you don't want to, we protect trademarks. You have a trademark, don't even come near the trademark. And me as a domain investor and as a business person too, I mostly think, listen, no one's going to come and get in your car, but I might walk right by it when I'm going into Trader Joe's. There's nothing you can do about it. I mean, so I might get real close to it. What were you going to
Yeah,
say?
trademark owners are very, look, a lot of trademark owners or trademark attorneys represent big portfolios. And as we've said on many occasions, 99% of the cases are abuse by or cyber squatting or abuse by the registrants. And so if you think about it, right, these people may oversee portfolios of hundreds of trademarks owned by one company. And in those hundreds of trademarks, they see thousands and thousands of sites or domains registered that they believe infringes on their customers' brands. And they'd be right. There probably are a large number. So trademark owners or trademark attorneys come from the view that there is no legitimate owner of a domain name except for the trademark owner itself. And and when you go to these INTA and you sit in and listen to some of this, I mean, you would think that uh, ICANN and the domain name community are all a bunch of thugs, and we're all bad people, and we're all just trying to make money off of them. Um, that it's an interesting experience to go to an INTA meeting and just hear the venom
Yeah.
that's spewed at those meetings.
I mean, they think, oh, I've seen this before. Like Jeff said, 95% of UDRP cases are clear-cut cases of cyber squatting. So even if it's very few of the domain investors are cyber squatters, sometimes they're really big investors. They own big portfolios. And it is true, 90% of the thousands of UDRP cases filed each year are clear cut. This is cyber squatting. So a lawyer walks up and goes, yeah, I've seen this before. And most often they're right. But that's why we focus on the 5% or less. It's a small amount, but still it's like problematic cases, like somebody going to jail or going to prison and they weren't guilty. So of course, we're saying the courts, the UDRP administrative hearings usually get them right in the vast majority of the cases, but when they get them wrong, it can really cause problems for legitimate business. I mean, really upend someone's business when it's a wrong decision, and that's why we focus on how can these wrong decisions be corrected. All the correct decisions, but go ahead. But okay, so that's why I bring up the very first case, GDOT, 4 letters, G, great, DOT, Department of Transportation. Anyway, the complainant in the case was Georgia Department of Transportation, okay? So we know what they do. It's a government agency out of Georgia. They filed this case against this domain investor, Nate Portney, out of California. Reason I saw it was because Doug Eisenberg on Twitter said, hey, I'm from Georgia, and that's one of my government agencies here in the state. Too bad they didn't win their, he said, unfortunately, they weren't successful. And I just noticed a guest that we have coming up, Sten Lillestrom, who's going to be here in 2 weeks from today. Sten is one of the top domain investors, in my opinion, especially somebody who he really understands naming. And when I say top, he came in this last decade, less than that, and really made big money investing in brandable names, meaning not these exact match names that everybody thinks, yeah, that's a good one. That must be a good one because that was exactly what I want, desktop computer. He is just a smart domain investor. You're going to want to mark your calendars for that show. That's 2 weeks from today, April 29th. But Sten made a comment when Doug put, hey, unfortunately, the Georgia Department of Transportation didn't win this case against this, dag nabbit domain investor who was cyber squatting, and Doug didn't say all that, but he did say unfortunately. And Sten said, why unfortunately? Yeah, and I felt the same thing. What, unfortunately, they like you think they should have won it. So I'm always like, even to friends, you're a lawyer, and you think, yeah, they should have won it. Why should they have won it? It's GDOT.com. Like I said, Georgia Department of Transportation files this case against, this domain investor. The government agency says, we have exclusive rights to this trademark in connection with anything transportation, services. And the complainant basically didn't like that on the site it said "girls delivered on time" was how they were using. They were saying that we registered this name, or this acronym GDOT stands for Girls Delivered on Time. And hold on, someone's at my door. I think they are here right on. Oh, my wife, she's at the horse right now, so I can say. Okay, so anyway, Girls Delivered on Time. The complainant was just upset that that's really, people are going to this website. They're thinking it's us. They're thinking we're affiliated with this nasty stuff. And it wasn't even nasty. We didn't even know what it was, what they even meant by Girls Delivered on Time, because the respondent, the registrant of the domain name, did not reply. Okay, did not reply to. So we don't know why he has, Girls Delivered on Time on the website, like what type of business is it. We didn't get anything. But basically, since Namecheap was the one where it was registered, Georgia Department of Transportation said Namecheap is disrupting our business, and the panelist said, I don't believe Namecheap's disrupting your business. It was Debrett Lyons was the panelist, single member. She said, I don't think they're disrupting your business, but I will say that, yeah, this person, you've made a prima facie case. Basically, I do think that this domain owner does not have is not using this in a bona fide way, because he didn't respond, and we need to know, what were you using this for? So this is not bona fide. The good news for the domain investor is the panelist said, I don't believe there was bad faith registration here, because we don't have information on that. The panelists did look and say, I don't see any other UDRP cases with this respondent, so I'm going to discard this, bad faith claim. Which, there's many things about this case that bother me. Like, what if you did find some other cases that was going to change your decision? So this panelist, did their own research, which some panelists don't. Anyway, I really had a problem with how this case, but it ended up being a complaint denied. So the domain owner got to keep their domain name. Now I've given away all the hints and clues and everything. But first to you, Jeff, and so we won't do it alphabetically. Give us some comments on this case, and why do you think it was even filed?
Yeah, well, look, Deborah, which I think is a he, it's not a she, I believe, is based in uh, Australia, I think. Um, an IP attorney is one of the fines in favor of a trademark owner a lot, right? He's not quite as bad as some of the others we've talked about, but you could tell in this decision that he was looking for ways to find in favor of the uh, trademark owner. And at the end of the day, he just couldn't. He couldn't find, that. Uh, and he looked. He did this outside research, which I kind of am a little bit bothered by. Um, but at the end of the day, he didn't find anything. But so what if he was looking at the website and I don't know, it wasn't active until 2023, I think is what he said. And you're right, he was looking for previous cyber squatting cases and he was looking for any excuse. But ultimately, at the end of the day, there was nothing there but this adult site. And in an adult site, there's an abbreviation which is plausible and has content related to that, you know, you got to do a better job as a complainant in trying to prove your case. And with a four-letter, something that's very pronounceable like G dot, um, you need to show more than just someone registered it and it points to an adult website. But you could tell, and it was touch and go there as you read through the case. I didn't know I wasn't convinced that he was going to rule for the respondent. In fact, in many ways, it sounded like he was going to rule for the trademark owner. Um, and I don't like the fact that, he said that there's no legitimate use and even got that far. But at the end of the day, it was the right decision. Don't like some of what we call the dicta it's the language that's not really related to the outcome of the case. But, as far as the result, it's the right result.
I like the result. I didn't like some of the dicta also. I don't think that this complaining was the right complaining. Like, okay, so Georgia got their trademark in 2020, 17 years after the domain was registered. So clearly there's no bad faith. The panel's trying to say, well, this guy is in California. How is he supposed to know that Georgia has a G dot? I used to live in California. I thought every state had a DMV. I didn't know that some states had a DOT for registering your driver's license or whatever. So yeah, that's not first thing that comes to your mind. Um,
Yeah, it's not. It's different than a DMV, DOT, Department of Transportation. It's like roads and stuff like that. So most states have a Department of Transportation, just like the federal government
Yeah,
does.
like Virginia has VDOT, right? So, you know, technically, not technically, we use VDOT here in Virginia, but still, I mean, it's a four-letter acronym or a four-letter domain name, could be an acronym, as was in this case, and uh, they got to show. I think they had showed common law rights, even though they just got the trademark. I think they showed common law rights that date back before the domain was registered. But um, but at the end of the day, it's the right result.
and if anybody else were uh, to have filed this complaint, I probably would have. It would probably been a closer call because, like, say, Green Dot Corporation used to actually be called G Dot Corporation, and that's their stock ticker symbol. But that the timing wasn't just right for that. But they pre-existed this domain name by 4 years, so they had the best possible claim against this domain name. But they didn't make it back then. They can't make it now.
Maybe there'll be a day. Okay, this respondent didn't reply, but maybe there'll be a day when they get an email from their registrar that says, "Hey, someone filed a complaint against you. Do you want to keep the name or not?" Meaning just anything to get an answer. It's almost like, "Hey, your name's up for renewal. Do you want to renew it or no? Your name has a complaint against it. Do you want to respond or no?" I mean, and at least then a no would be, we know that you were made aware of the complaint, because we're just seeing too many complaints where there's no reply, and I don't know if it's always intended. I think sometimes they just don't recognize it. So anyway, to sum up that case, it was GDOT, Georgia Department of Transportation, filed this claim. Should it have been a reverse domain name hijacking? Well, that's an argument that can be made. But this panelist, like Jeff said, no, they're looking through old cases, and as a domain owner, sometimes you want them to look back and say, hey, do some research, and you'll see that I've used this legitimately, or I've had it a long time. But then, of course, you don't like them doing research to find out, let's see if there's other UDRP cases with this respondent. And what if this respondent, I guess if he would have won UDRP cases and had shown answers in those previous cases, maybe that would have helped. But it's just weird that, the panelists do some research in some cases and others they don't. And I was made aware, it was Charlie who mentioned, he's a panelist, Charlie K. I won't say his last name, but anyway, he's the one that mentioned to me that he, when a case is submitted, he looks through the evidence. That's the main thing. Looks through what's submitted. All the claims made by the complainant specifically, the respondent too, but mostly the claims made by the complainant, well, those don't mean much if there's not evidence to support it. So I do like that the panelists, immediately look at the evidence, but to go ahead and start trying to find new evidence when it wasn't brought up by the complainant, yeah, that's some bullshit. Okay, so the next case, so the person got to keep GDOT. Nate didn't reply, but he did get to keep it. Now, in these next cases, there's responses by both, by the domain owners. They either have attorneys in this next case, or they responded themselves in the third case. This next case is freightquotecalculator.com. Interesting case because this a company out of New York, C.H. Robinson, a worldwide company, filed this against Luke Perry. No, Luke Petty. Luke Perry, RIP. All right, Luke Petty out of Michigan. The complainant owns a trademark to Freight Quote and operates on freightquote.com. The disputed domain in question here is freightquotecalculator.com. So, the respondent, the domain owner here, operates a company called STB Freight Brokers. And what he does on the website is he offers an AI-powered freight quote calculator. Okay, so the respondent said, I'll get into his response already. He said, hey, I registered this name because I offer exactly that. It's a freight quote calculator. It's as descriptive as it gets. So I registered the name. Don't even know about this other place. I'm not trying to infringe on somebody else's mark. I'm not trying to use the goodwill of somebody else's mark or any bullshit like that. I'm offering a freight quote calculator. So I registered freightquotecalculator.com. It's that simple. But the complainant, is saying, it's saying several things that, listen, this is obviously confusing to our trademark freight quote because they've added this one other word on there, calculator. And, we feel, I guess, when they're trying to impress the panelist, Natalie Dreyfus, who was a single member panelist, to say, hey, look, so freight quote calculator is confusing to our mark and it's not identical, but it is confusingly similar. And Natalie said, I agree with that. So we'll go to the second prong, which is, does the respondent in this case have legitimate use? And the respondent says, I'm legitimately using it. I just told you I'm offering AI-powered freight quotes on there. And, the disputed domain was registered to accurately describe my services. Well, and furthermore, respondent said didn't know of the complainant at the time of registration. So it really is looking good, in my opinion, for the respondent because he's saying, hey, listen, I have legitimate use. I'm showing it and all this. But yet Natalie says there's no legitimate use. This domain owner has not proven that he's using this in a bona fide way, and furthermore says it was registered in bad faith and being used in bad faith by offering this AI freight quote calculator. Now, there's some, a lot more information to this case, and I've heard comments from some colleagues and some attorneys about how they view this case, and I'm going to bring them up. But first, Jeff, what comments do you have about this case, freight quote calculator? And I've given away that this was a transfer. This got transferred away from the domain owner, I think unrightfully so, but go ahead.
Yeah, I mean, I would not have considered, I would not have made the decision this way. This wouldn't have been my decision, right? I think I would have kicked it out as being sort of beyond the scope. And if the complainant wants to allege trademark infringement, it certainly can do that because it's got a valid trademark for freight quote, whether we like it or not. And so therefore, it seems ripe for an infringement, but it's certainly not cyber squatting. And I was a little bit annoyed because essentially Natalie said, well, the respondent, now I'm saying Luke Perry, geez. There's probably a lot of people, Todd, that don't even know that reference on this. That shows you we're just getting old. By the way, for you younger folks, Luke Perry was on a show called 90210. You could check that out. Anyway, as I did every, what was it, Sunday nights or Wednesday nights? Anyway, she just basically said, and I did. This is the part I didn't like. She said, "Well, this Luke Petty person says they're representing STB Freight or whatever it was, but hasn't proven it. Hasn't shown a legal document." And I'm like, did she do that for the complainant? Like, since if she didn't have certainty, or there was any doubt in her mind that this Luke Petty person was representing the respondent, or the freight company, she should have asked the question through a procedural order. Her disbelief is not enough to justify that there's no legitimate use. If anything, she should have just gone to the third element. And on the third element, like I said, I think this is a trademark infringement action at its core, and therefore not appropriate to decide under the UDRP. So that's how I would have kind of addressed this, because uh, it is two perspective, or two different businesses that are using kind of the similar marks, and it's not what the UDRP was supposed to address.
Yeah, I agree with that. And also, this freight quote trademark that the complaint asserted, initially they got a registration on a supplemental register. They tried to show all kinds of usage and prove that it should be on the principal register, and they failed to do that. And then they applied again. There were some incoming lawsuits, and then this big company that's the current complainant acquired the domain name through a transfer, and they are now the owner, and they're asserting it to put out their competition. The complaint is a publicly traded corporation, maybe the third largest freight brokerage company in America, and it's weaponizing a generic term to put down its competition. That's a Sherman Act violation. Section 2 of the Sherman Act prohibits the use of generic terms to the exclusion of your competitors. It's a problem, so they should not be doing that.
But David, hold on. You said with the exclusion of your competitors. It's an important note because they're saying this is a competitor.
Yeah. And if you look at the website, if you go down to the contact us link, it actually goes to this freight company. So you have the contact information there, the address and everything. So what is the problem?
Well, I'm going to bring up, I was communicating with Nat Cohen about this and also John Berryhill, and I want to bring up, so Nat brought up a point that the complainant, as you mentioned, overcame the examining attorney's non-final action letters, what they call it, on the basis of the genericness. So how did they do that? Because the complainant said, okay, so this thing is generic, a generic phrase, freight quote, and they didn't get their original application registered. They didn't get their trademark, and it got put in the supplemental registry, like David said. But then they responded back to the examining attorney and said, we are not using this in the generic sense as just a freight quote. We are using this in a different class altogether, in a different usage. It's not, we're not offering just freight quotes here, although they sort of muddy the water because they are offering quotes, but they specifically told the examining attorney, we're doing this in another category and we're not using it in a generic sense. So the examining attorney said, okay, let me stamp this baby. I don't know how it works. And they gave them a registration, and now they got this registration, and they're going out and doing exactly that. They're using the registration to tell this other company, Freight Quote Calculator, you can't use it as a quote calculator. But then you told the examining attorney at the trademark office that you weren't using it as a quote calculator. So how can you have it both ways? And it seems like, okay, so I was full on. I'm usually full on with what Nat says because as domain investors, we stick together. I mean, tight. Anyway, then John Berryhill made a point about all I can remember is he said, United Airlines can't say we are the number one American Airlines. Okay. And he was trying to make the point that United Airlines can't use American Airlines trademark and get away with it just because using it in a generic sense. So that really made sense to me too, meaning, all right, so it sounds like big court arguments to me, like, I don't know. So when Natalie ruled 1, 2, 3 that the complainant met all, was successful at all aspects of the UDRP and transferred the domain freight quote calculator to the complainant, I think this is an obvious one of, geez, if there's infringement, go to court. This person had legitimate use to the name and didn't. I don't see any proof of bad faith registration, although Natalie did. So this was just I think a bad decision in that sense. But I think there are some great arguments on both sides. But that needs to be in court and needs to be really drawn out anyway. So there was a transfer. Any other comments on this thing about what I just brought up?
Well, that's an important point, how their first application claimed freight brokerage of freight shipping and delivery services, and that went in the supplemental register. And the second one was information management services, namely shipping, processing, preparing shipping documents and invoices, tracking documents, and then freight brokerage services as their list of services. So class 35 is the information part, the freight brokerage services in class 39, but they're still related. The examiner never allowed this trademark.
Well, but they did, right? And so the examiner allowed it, and this company's got every right to enforce its trademark. But just like others have the right to use things in a descriptive sense. And, it's like, right, booking.com, right? Booking finally has their trademark for booking.com. Took a while, took some Supreme Court case, but they got it. So if someone wants to do hotelbooking.com for booking of hotels, I think they'd be in the same position where that would be infringement. You may not like it, they're using booking in its generic sense, but they can't have hotelbooking.com and do the exact same thing. Right? That's just the way trademark law works.
Not really, because the Sherman Act, Part 2,
it
prohibits that.
You'll trust me. The Sherman Act would not be invoked if someone were enforcing their trademark that they've been given by the U.S. Patent and Trademark Office. Right? So they're using the federal government's grant of a trademark right. And so they would not be found in violation of the Sherman Act to prevent someone else from using hotelbooking.com.
Yeah, with John Berryhill's example of United Airlines not being able to use, we are the best American airlines out there, something like that. It's a little different than a company using hotel bookings, but I can, they're generic. Well, let me say, hey, John D., welcome to the stage. Do you have a comment on this or a question after we're done with the UDRPs?
Oh, yeah, hello to the space. I don't want to jump in at this point. I was trying to jump in just to see if anyone was aware of who runs ESQ Wire, because if they are aware of who those lawyers are, there's still time to save that domain ALO.
John, you're funny that you said that because I had written down. Of course, we know who runs it: Jason Schaefer and Ari Goldberger. But I just had written down Jason Schaefer, ALO. I'll see if Jason will be here, if he can join us next week when we go over, and I'll talk to him before that. If he can go over what he thinks ALO can do. Maybe they don't want to pay to, it costs a lot of money to defend yourself in a court case as opposed to, defending yourself in a UDRP. But thank you for bringing that up, because I had written it down too to say, hey, let's get Jason in here next week. And he was successful in defending the registrant in ALO.com UDRP case and won it. The registrant got to keep the name, but now it was taken away. So Yeah, John, right on. I mean, that's exactly what we want to know. Hey, were you? I'll ask Jason. Were you contacted? Was it the reason why you're not representing? It's probably have to do with money, or he just wasn't contacted. And then also ask, well, what can be done to try to successfully, retain this name? But
Because some of the lawyers out there that are listening, I've listened to lawyers in the past on cases like this, and I know that in the case of Sex.com, the lawyers actually took a share in the domain, victory if they won. And if it's a money issue, I mean, clearly, the yoga company. This to me is an example of predatory targeting of domain owners. When you look at the UDRP case, that was a 3-panel decision. You guys mentioned Attorney Eisenberg. Eisenberg is no big friend of domainers, but at least in his cases, he tends to be fair when he's on panels. And he was on that panel 3-0 that decided in favor of the domain registrant. When you look at the actual filing of the motion in Virginia, where again, here we have Wiley Rain at it again. They were the law firm that represented the PRU.com case that favored Prudential at the court level. But the difference between the two cases that they pursued with the same goal is that in the PRU.com case, they initially were going to file a UDRP. They went through the whole process. But what happened, the registrant at that time, which is again a foreign registrant located somewhere like in China or something like that, was involved, which is very similar to this case right now with ALO as an acronym, where you have a Korean citizen located all the way in Korea that was represented by ESQ at that time, where it brings in the question, are subpoenas arriving? Are these registrants even receiving the case notes from the jurisdiction in the U.S.? Not the U.S. We don't know. But in both cases, Wiley Ryan predatorily was involved in helping a complainant pursue a domainer after either planning to file a UDRP and pulling it, or in the case of ALO, losing with an RDNH with a panel that was not known for being favorable to domainers. So I think that there's something that's a little bit more insidious going on, where if you read the PRU.com decision from Wiley Ryan, which represented that complainant, they're going after these foreign registrants with these acronyms, and they have like a 2-pronged strategy. The first strategy is that they want to overturn the definition of registration. This is serious business for those that call themselves domain investors. If they successfully redefine registration, Wiley Ryan's plan is to get it redefined as the moment that a domain is renewed, it resets the clock. If it's sold, it resets the clock. That way, they can come along and they can present themselves to trademark holders and corporations as, we can go get 90% of these domains that are out there in the aftermarket to these high-value clients. We can go get them now because we redefine registration. And then the second thing that they're going after is this in-rem thing. Even in cases where we're not sure that all efforts were made to subpoena the domain registrant. So I'm just saying that if you guys can, make those calls, it'll be very appreciated, because this is not a case that you can just let slide by, because there's a way bigger thing going on here where they're really targeting registrants. In this case, you're talking about a 8-year pursuit. This is the whole reason that bad faith is supposed to be on the side of both parties, not just one side. Bad faith was represented when the RDNH happened. It was said there right in the UDRP filing that it was bad faith, it was hijacking, and it's harassment. I didn't see any mention of that UDRP in the motion filed by Wiley Ryan in the Virginia court again in relation to ALO. So I think that if there's still time, which is usually 30 to 60 days, something needs to be done to help this registrant make sure for sure that, oh, I just let it drop. That's a 6-figure domain. And they have a very aggressive, predatory complainant that wants it. There's a lawyer that can help take that case if there's still time to file an appeal and get a share of that domain if it wins in court.
go ahead,
So,
Jeff. I'm so riled up right now. John got me going crazy.
all right.
I'm gonna
Yeah,
get.
no, it's great comments, John. I mean, it's, there's a lot of people that share your sentiment, and but the issue here is that the default was entered on the 17th of September last year. So the website's already been transferred. It's not that you can't appeal it to try to get it back, but it's a little old at this point to go back over. Um, so even though I don't know why it was just reported today by DNW, but the order I'm looking at was dated September 17th, 2024. And I'm trying to look to see what, uh, if anyone, what the order was to see if they, how to serve the client. So I think there was a motion. Yeah, there was. Okay. So I'm looking at the PACER report. So there was a motion to serve by electronic means. So they did serve. Let me look at this order. And I don't know why the ALO.com registrant didn't respond, but in this case, let's see. No, that wasn't signed. Anyway, we can discuss it next week because I do want to look into it more. But the decision came out in September.
Yeah, I'm going to reach out and speak to several attorneys over this next week and talk about what can be done here. I mean, and one, just keeping people aware of it, even if some things, the water's already under the bridge. I don't know what term I'm looking for. But the point is, I didn't realize it was this court case was decided or the domain was transferred 6 months ago, 7 months ago, because that will limit some things that can be done. But anyway, so next week, John, we're going to talk specifically about this case, and we'll have much more information on it, and we'll see if Jason Schaefer can join us. It really is bothersome because Jeff had brought up before that, the Ninth Circuit recognizes the original registration date, but with court cases being up, new cases being filed all the time, that this may change. And what John brings up is a good point, that this in rem case filed in Arizona, that's Ninth Circuit, could make, be a foundation for changes to how the Ninth Circuit sees domain registration currently. So, and he's right. We've all known that. Listen, when a domain's purchased on the aftermarket, we don't want that to necessarily, definitely as a domain investor, we don't want that new registration date or that new acquisition date to be used against us. We're purchasing that name because of sometimes of the goodwill, the legalness of it from that original registrant. But it brings up a lot of good points, John. So we're going to really dig deep into allo.com, and we're going to, like I said, talk with the attorneys that successfully defended them in UDRP. But yeah, when we're familiar with the Prue case, when I say familiar with it, because there's so many cases, I can't remember all the details of that. But thanks for bringing those up, and I know you likely will. But next week will be a good show. We're going to cover this. We got one more case today that I want to get to so we can get out of here, go play on the playground, and that is geoip.com. And before I get into this case, so this is a 5-letter domain name, geoip.com. I mentioned earlier on Friday we're going to be talking to Josh Reason and I are doing a room about domain investing. And there was a comment earlier on X this week about somebody said, hey, I can't believe it. I registered a 5-letter domain name and it was still available. And a lot of people are making comments like, God, it must have been a shitty name because there's no good 5-letter domain names that are still available. Sure, not great brandables and stuff like that, but I'll say this, and we're going to talk about it this Friday, and it's 11 a.m. Pacific, 2 p.m. Eastern. So mark it on your calendars. We're going to talk about, I have a friend that has a new beverage company, and I find that his domain, basically his initials, 2 initials plus the word bev.com is available. I bring it up because, 5-letter, I don't know, I didn't do the math on 26 times 26 times 26 times 26 times 20. There's a lot of 5-letter, names, and there are a lot of stuff that's still available, abbreviations for companies. So don't let people tell you that, no, there's no good 5-letter.com left. Your company, your acronym may be available, and I find it, found many times for customers, and we're going to talk about it on Friday, meaning I'm going to show you, yeah, what's your new company name? We could probably find something in the aftermarket for less than $100, but probably find a good name to register. It's not always great for domain investors because we're thinking, fuck, we'd like people to think everything's gone, but not true. So this next case, geoip.com is the domain name. GeoIP. Well, when I look at it, I think, all right, well, we, as domainers, we use a lot of this IP tools. Who visited our website? Where are they from? Oh, they're from France. I had somebody from Paris. They're trying to break into some of my websites today. Lucky, because I had to search their IP address. But in this case, MaxMind is the complainant. This was against the domain owner, domain administrator. So we don't know who it was. But after I see this case and I read the summary and I see that it was the case was, the domain was under this Anonymize LLC, which and was registered at Epic. So it already tells me, okay, so this is a domain that was held at Epic. They used their Anonymize service to keep the registration private. And then I see this domain owner answered himself. It almost sounds like a Rob Monster domain, and he answered himself because the person, like I said, the respondent, the domain owner, answered on his own behalf. That last case, the freight calculator, that was the flat out lawyers answering for the respondent and lost the case. So it's one thing when lawyers lose it for you. You lose it yourself. At least you're not out all the money, and you're not mad at your attorneys. But in this case, so the domain geoip.com was acquired at public auction in June 2014. I see on Name Bio that it was purchased through NameJet for $2,150. So a lot of us do that. If you saw GEOIP, I know tons of domain investors would go, yeah, I'd pick it up, maybe even for that $2,150. So the complainant in this case was founded in 2002. That's an important date because they provide IP intelligence and online fraud protection, and just like you would think they would with GEOIP. Now, I told you the company name is MaxMind. They have a trademark for GEOIP. That's one of their products. They offer a bunch of products. The GEOIP product is not free. They do offer some free products, but that's not free. So the domain name geoip.com, that's the disputed one here. Jeff, go on mute just so I don't have to hear the clicking. And then the GEOIP was picked up at public auction, like I said, in 2014, but the original registration date was in 2000. So when this respondent is responding to this complaint, says, hey, this domain name was registered or was created 2 years before this company was even founded. However, Charles Gibson, who's the single member panelist here, says later on that no, you acquired it in 2014, which is many years after this trademark. This trademark, you guys are both in the U.S., and because the panelists did find out, okay, this individual is from Spokane, Washington, this respondent. And the respondent did, reply and say, hey, I'm a cyber security professional. I've invested significant resources in this website, geoip.com, for people to use it free and to be able to locate any IP address. And that's what it said right on the website, geoip.com, locate any IP address. And the respondent, I'll say quickly, made a interesting request to the complainant, because the complainant had reached out to the respondent and said, hey, you're using our tools to provide information on your site. So either attribute the data you're providing for free to us or quit using our stuff altogether. And the domain owner said, I'm not using your stuff. I'm not using your data. And if you want, go ahead and restrict access to your website from, I don't know, basically said, restrict the API usage so then you can see that all the data coming from my site is not you. Well, the complainant filed a supplemental. They both filed supplemental filings saying, okay, for one, I can't do that. It's free service. It's data that you can download, so I can't keep you from getting it. I can't block you like you're saying. So, the long story short is the complainant did make their case, and the respondent did answer every, piece of the case, but the panelists still said GEOIP is, confusingly similar to their trademark because they have a trademark for GEOIP as a product. And two, you're not showing me that you have a legitimate use. You're using it for the exact same thing, but what else are you going to use GEOIP for? So I'm telling you, the complainant said there's no really a bona fide use here. You're infringing. You're basically using it for the same thing, which I think anything is a court case. And third, that you're both American companies. This is a well-known mark, which isn't really well-known. So the panelist ruled against the domain owner and transferred the domain name away. And I'll finish by saying in the supplemental filing for the respondent, they brought up like, hey, there's a Portuguese company using this trademark. There's other people. I think he did an okay job in responding to this complaint, but wasn't successful. So the name was transferred away. David, I guess we'll go to you first. What do you have to say about GEOIP.com, this case, and how could the respondent answer differently to hold on to his name?
Well, when I saw the decision last week, I was shocked. But I didn't read it right away. But GeoIP seems extremely descriptive to me. I Googled it, and it's the geographic IP location. It seems to be an industry term. It's listed on a bunch of websites. There is no constructive notice under the UDRP. So you can't just say, well, you're both American and you have, constructive notice of a USPTO trademark registration. Now let's move on to that USPTO trademark registration. It was applied for in 2003. In January 2004, the attorney for the complainant responded to the examining attorney who asked whether the letters GEOIP have any significance in relation to the trade or industry or as applied to the services. And they replied, GeoIP is not a common term that is used in the industry or for this service. It is a term coined by the applicant, which combines elements of the word geography, internet, and protocol. That was submitted January 20th, 2004. That's the basis of this registration. I think that was a fraudulent statement, but you know what? I wasn't looking at these IP addresses back in 2004, so I don't know one way or the other what was the status of that term back in 2004. Do you guys know?
Yeah, so the term as it was used back then was IP geolocation. So it's basically taking the two words, reversing them, and shortening it. So I think it was fine at the time for them to make that. If they had called themselves IP Geo, they probably may have had a problem. It's makes me think of the term digital identity, right? That we all know is a generic term, but we have a company that's called Identity Digital, and Identity Digital is a trademark, right? Because it reverses the words, even though the two-word combination, digital identity, it's the same whether you say one word first or the other word first, but it makes a difference. And in this case, GeoIP was not the term that was used. It was IP geolocation. And the reason I know that is because in 2006, 7, after I was at Newstar and we were acquiring IP geolocation services through a company called Webmetrics, and we were using it for DNS. So yeah, when you say IP geolocation, that is very descriptive and generic, but GeoIP is not.
You know what?
Yeah.
I just used Google Trends, which actually goes back to January 2004. Did a worldwide global search on the two-word combination of GeoIP, and it shows significantly more searches for GeoIP back then than it does now. It seems to have been a common industry term, and GeoIP tool was like a related topic. But this is according to Google Trends, which tracks the stuff. That's probably what I would have used to figure
But
this out.
Google doesn't care whether you have one word first or the other word in its algorithm, right?
Yeah, it
So
does. Like, let me compare with IP geo. Let me see if that's a difference. So I can do that. It's actually 50-50 used both ways since then, which is odd. What do you think, Todd?
I
Do you
think that,
remember?
I mean, Google obviously recognizes word order, but I mean, it in some capacity. I know that for a fact. But in this case, the panelist who said, you know, the complainant's trademark was known, and the respondent had willful blindness. It's not. I mean, he just says it. There's no proof that the respondent was willfully blind to this trademark. I mean, it just so. And even if he was, but there was no proof of it. And the panelist also said, not being aware of complainant's trademark does not excuse the respondent anyway. Just made all sorts of claims, basically figuring out a way to transfer this domain away, or you know, just really seemed like
yeah,
avoiding it.
well, look, even though I think GeoIP is different than it's not necessarily generic, I still think that this was another case that should have gone to court as opposed to the UDRP. And I think, again, I would say it's beyond the scope of this, of the UDRP. Whether one's infringing or the other is not necessarily an issue of bad faith. Right? You could be infringing and not have registered the name in bad faith.
All right, what a great day. Okay, so there's a couple announcements I want to make. Two things that I think you'll want to attend over the next few days. Tomorrow, there's a domain transfer policy conversation. Zach Muscovich, who's the general counsel for the Internet Commerce Association, is moderating this. And it's, I think, very important, really just to understand yourself, hear it from the experts, and that is understand. So, what's changing with domain name transfers? I mean, what is the new policy? And what you can do is go to our website where the outline is dnlshow.com/outline, and you'll see on there B B5. It's B5 as in bingo. ICA expert call on ICANN's proposed new domain name transfer policy. So you can go right there to our outline, dnlshow.com/outline, and B5. You can click that link and you can sign up to be on the call. As Jeff mentioned, if you're an ICA member, you can listen to it on replay. If you're not an ICA member, check out internetcommerce.org. And for as little as $25 a month, you can become a member. And it's hugely valuable for several reasons. But anyway, so check that out tomorrow. That's tomorrow morning, Wednesday, 10 a.m. Pacific, 1 p.m. Eastern. I know, because it's 10 a.m. for me. I'll be listening for certain. And then on Friday, I mentioned Josh Reason and I are doing a space on domain investing. Okay, we're going to be talking about not only trends, we have a lot of great topics, important topics for domain investors to consider and think about. And one of them, by the way, is all these names being posted on Twitter. Hey, I sold this name. I can't tell you the name. What are they doing? I can't tell you the price. You know, I mean, I just don't think the stuff is valuable, but I mean, sure, you can find a little bit valuable from anything. Like, I can't tell you the name, but it was on this extension, and I can't tell you the price, but I'll say that I 10 times my money. Sure, if you're somebody who's just wanting to extract, you know, any type of data, I guess there's something there, but we're going to talk about, you know, things like that, and then more serious things that can make you money, you know, domain investing. So that's Friday, 11 a.m. Pacific, 2 p.m. Eastern, and you can check out on my timeline the link. You know, I posted it, and I'm going to post about it a couple more times before the show, but that's Friday. So tomorrow and Friday, a couple good things. A seminar tomorrow on domain transfers, and then a X Space on Friday, talk about domain investing. Till then, I hope everybody has a great rest of your week, great evening, day, wherever you're at. Thanks for joining us today, and we'll see you next week. Please be here next week for Domain Name Law Show. Same place, same time. That's next Tuesday, noon Pacific, 3 p.m. Eastern. We're going to talk about this ALO.com case. I think it's really important to dig deep, dive deep on that one and talk about it. All right, that's it for today. Hold on, there's a request. Let's see who this is. Okay, Fabian. No, I'm going to go ahead and close it. No, Fabian, I'll go ahead and let you up. We'll see what Fabian has to say so we can get this out of the way. Maybe never have to interact with Fabian again. Just kidding, Fabian. I've never met you, but it's nice to have you here. You look good in the hat. What's up?
Hey, I have the name pill.bot, Pillbot, and there's this company called EndiaTX, EndiaTX.com. And on their homepage, it says introducing Pillbot with a trademark symbol, but their trademark's been dead. Here it says it's dead, dismissed since May of last year. I just want to know if it's safe to outbound to them.
Whoa, I'll let the lawyers answer, but I mean, and we might talk more about it next week because I have a similar thing. I own Land.bot, and there's a company, Landbot, that has AI agents. Okay, so to first of all, Fabian, there's several different categories, so you're probably safe, right, owning the name and using it in a different category if you come after them, if they do have, say, predated trademark on Pillbot. You said it's already abandoned, but let's say that it's not, and they're using Pillbot as something. Well, you wouldn't want to, and they have it registered, you wouldn't want to go in that same category, but if you're using it in a different category, because it's certainly not a super famous mark, you could, be okay there. Contacting them, can turn into targeting, meaning, you contact them. I'll give you one piece of advice and then we'll see what the lawyers have to say. And that is, I would, if you're reaching out to them, find 5 or 10 or 20 different people to reach out to for the same reason who are using something, just anything. And then you can let them know, let whoever you're contacting know you're reaching out to several potential users that you think could benefit from this. You're not targeting just one, and that may go a long way later on if someone says you're targeting just us solely. But let's see.
Right.
What do you say, Jeff? What do you say, Dave?
I'll let David go first.
All right. First, do a trademark search to see what's the status of those trademarks and why they were refused. I see one of them was refused because of merely descriptiveness. That's a Section 2E1 refusal. But none of them are registered in the USPTO currently. They might be registered in other countries, so be careful about that. But generate your list, maybe share that list with them. And, that gives them a timeline. It's like, okay, these are the other, my competitor or these other unrelated companies might get it. And there's a high likelihood that they will buy that domain name. So I'm not going to delay. I'm going to grab it while I can if it's really important to me. But yeah, it's been used for computer controlled tablet packaging machines, for detecting pills, for dispensers. So organizers, pill organizers. It's a generic term.
Got it.
Yeah, I mean, I think like I never advise to reach out to a trademark owner directly because of targeting. But if you're going to reach out to them, reach out to a lot of others. Just don't make it that you're targeting that one company because that will lead to bad results. Plus, I'm sure there's a lot more companies. Well, they may not be the highest paying customer anyway. So, reach out to do a general outbound as opposed to a very specific one to just this entity.
Yeah, that makes a lot of sense. I appreciate it. Yeah, we'll do that. Send it to a bunch of different companies with that Pillbot name. And I really like Land.bot, by the way. That's a solid name you got there, Todd.
Yeah, thanks, Fabian. And one more thing about your situation is, David alluded to it, do a trademark search, do a general search, obviously, and you're going to find probably some common law marks, people using and you know, forget the extension. Of course, people are using pill for all sorts of things. So you don't have to just look for PillBot. My point is people using the term pill in whatever crazy category, could be, you know, I'd say toys, okay, anything that, you know, some kind of service. You can reach out to those places, and sometimes I think it may be beneficial. So you have, if there was ever a trademark owner that sent you a cease and desist, or filed a UDRP against you, you could always say, hey, look, hey, I have records that in April of 2025, I contacted these companies. I didn't contact this company until May. You know, I'd already contacted another 10 prior to that. Of course, you're not going to know which ones are going to think you're targeting them, because you could contact somebody with a common law mark and they think it's the same thing. You're targeting me. So, you know, you're not going to, you know, send everybody the same day. I mean, sometimes if you're really suspect or concerned about someone, like I said, using PillBot, and you're thinking, geez, they would maybe more think I'm targeting them as opposed to someone with just pill, then send some emails out, you know, and always let them know that they're not the only person you're sending to. But then later on, if somebody comes after you too, you could always, or, you know, files against you, you can always show, hey, here's all my records of all the different parties I contacted. But thanks for asking the question. Thanks for joining us.
Yeah,
And,
thank you. And did you guys see that a .ad was sold on Atom? I think like a few days ago. So I guess that must have slipped through the cracks, I guess. Because I
Yeah.
remember asking you guys about .ad a couple of weeks ago, I think.
Yeah, and that was I did see that, and
Create,
yeah,
create.ad.
create.ad, they had a big little grok fucking, you know, image they created or something. But anyway, yeah, I did see that. And of course, if anybody wants to know, .ad is from the company Adventure. No, I don't. What was the country that's
Oh,
from?
Andorra.
Andorra. Oh, Andorra. Okay, very good. When you say Andorra, I was thinking that's Agnes Moorehead from Bewitched. Okay, Andorra, and right. They had a rule that you can't resell the names. But what I mentioned was, and I remember you being here, Fabian, that many times these countries will loosen up on some of the restrictions, meaning, okay, and hopefully that's what Andorra's doing, because I own want.ad, because I always thought one ad's a good one, and vehicles.ad, and I think I own sportsbook.ad.
That's a good one. I
But
like it.
so the thing is, I saw that and I definitely like seeing that. So yeah, yeah, you need to join us on Friday when Josh and I are talking about some of these CCTLDs. We're going to talk about, that's where I believe there's opportunity, and some of them are going to not necessarily take off, but some of them are going to be fruitful and prosperous investments, and a lot of them are just going to be, you know, a waste. And it's hard to, you know, understand which ones may be something. But it is important to see, like create.ad get sold through Atom. One, maybe Atom now will take some of our good .ad names. But thanks for bringing up the two things you brought up. Interesting stuff. But hope to see you Friday, and then come on stage Friday. It's going to be an open conversation, open discussion, where we're going to just, you know, throw around what we think are good domain investments, and definitely like to hear from you guys. But thanks
Yeah,
again.
I appreciate it. Thanks, Don.
See you on Friday. Hey, and John, thanks a lot for joining us. Made a lot of good points. You got me all crazy. I was going to go out on Wilshire and start marching. Man, we're taking shit back. All right, everybody, have a great evening. That's it for today. Great day. Talk to you later.